think you're going to find Cara very interesting. Please welcome Cara Griffith.
Thank you. Now let's see if I can manage to work this. Okay, so we can skip over that. So a little bit of an introduction. What I'm going to hope to do is to not bore you for 40 minutes and to give you a little bit of insight into what I really have been doing for the transparency stuff. Really has been like a 3-year project of looking at state tax systems, looking at transparency, and how can they be better. To give you a little bit of background and history into the company that I work for, Tax Analysts, is about, I think it's about 45 years old now. It was founded by a man who thought that the IRS was not transparent enough, and the IRS was keeping important guidance hidden, and something needed to be done about it. And so he really, he took it upon himself to use FOIA, really develop the law of FOIA, the Freedom of Information Act, to obtain documents. And so through a variety of lawsuits that Tax Analysts has been involved in, we've gotten the IRS to publish private letter rulings and to publish TAMs, Taxpayer Advice Memoranda, and a whole bunch of other alphabet soup documents, which all provided guidance into what he considered was secret law. It was the internal working law of the agency that those inside the agency knew, but taxpayers did not. And so for the longest time, Tax Analysts was very focused on the federal level, and just recently we decided, well, we had transparency concerns at the federal level, there probably are at the state level as well. And so it's been really an interesting dive into some of the differences between how the states and the federal government work, and then some of the transparency concerns. So I'm going to do a quick little overview of kind of Washington's tax system. You all are probably somewhat familiar, but I think it deserves mention because Washington's tax system, particularly the B&O tax, is different, and that the difference in how the B&O tax function kind of plays into how much transparency and the type of transparency that we can have. So I will try to kind of glide through this and get into more of the fun stuff. So as you all are probably very well aware, you have no income tax here, no corporate income tax. And your property tax rate is pretty average, as I found out. I kind of thought they were going to be a little bit higher, but it's pretty good. So, you know, all in all, it sounds pretty good. But then if you read some reports, Washington's tax system has been described as among the most regressive in the nation. And so, you know, why is that? Well, it's because of the sales and use tax. The sales and use tax is widely thought of as a regressive tax because it is imposed on essentials. And so if a low-income person is buying essentials, more of what they put towards their essentials is going to be taxed. And the Washington sales tax rate, that's high. It's the 6.5 rate, which actually isn't all that bad, but there are so many localities that it impose a rate on top of that. So you guys pay a lot in sales and use tax. Now, if you looked at the total tax burden, because there's no income tax, it's probably evening itself out, but you know, we pay it where we pay it. But so the B&O tax is super unique, I think. So I'm an outsider. I will note that. It is a gross receipts tax. Gross receipts tax is a bit of a trend in the state and local tax world at the moment. The gross receipts tax is, in fact, a tax on gross receipts. It is not a tax on income. So the tax is imposed whether a business is profitable, whether a business actually is showing income. It is going to be imposed on their gross receipts. So you can no doubt guess that businesses don't like it very much. But really, one of the biggest things that gross receipts taxes do that tax policy folks don't like is it's pyramiding. So you're going to have, because it's being taxed on receipts, you're going to have levels of tax as an item goes through the process. So if you have an item and then it's going to go through the manufacturing and then it's going to go through something else, it's getting taxed at each level. So a pure tax policy specialist is going to say that's a no-no. We do not like tax pyramiding. We want it only to, we want tax only on the final good. And gross receipts taxes are unique in and of themselves in a way, but the B&O tax is just incredibly complex. Again, speaking as somebody who is an outsider, rates vary widely. There are tons of exemptions. The classifications are really what get me, and I put this up here. Not that I'm going to even try to read through that, but you sort of talk to taxpayers about the B&O tax, talk to practitioners about the B&O tax, and it's complex. A single taxpayer can have multiple classifications, so then they have to delve out and divide their income and say, well, what receipts can we allocate to this, what can we allocate to that, and it's all going to get taxed at a slightly different rate. It seems to me, from watching it, that there is a proposal every year to simplify the B&O tax. I suppose it's something, they may be able to simplify the classifications, but there's also usually a proposal to repeal it, and then we're going to adopt an income tax. That is unlikely to happen, I think. And Gil could speak to it later. I think it's highly unlikely to happen. It would be such a massive change, and to get a government to do a massive change like switching and from a major tax stream is, I think it's highly unlikely. See, I got ahead of my... Yeah, Washington voters have voted at least 10 times on a state income tax, and you guys don't like it, so I see the B&O tax as sticking. So 2 more little points, and then I'll get into transparency. I wanted to address briefly click-through Nexus, in large part because this is a huge trend in the state and local tax world. And it's one that Washington is not, it's not really on the forefront of it. I think they're running with it. Click-through Nexus is the idea that an out-of-state seller must collect and remit sales tax to the state if it pays in-state website operators or individuals to refer online shoppers to buy from retailers, and those referrals are worth more than a de minimis amount. This was first conceived of in New York. I had the pleasure of speaking with Robert Plattner, who may have been the brains behind this concept. And I was really kind of against this when it came out a couple years ago. I wrote a couple articles. I was at PwC at the time on what a bad idea I thought it was, and they were stretching the attributional nexus rules and this and that. And I have to say, after I talked to Robert Plattner about it, I was like, oh, wow, maybe I was wrong. That makes a lot of sense. But you tie that in then with economic nexus, which is the concept that a business does not need to have a physical presence in a state in order to be subject to tax. And I think that the trend is going to be that a case called Quill is going to be reconsidered sometime soon. It is certainly ripe for reconsideration. So I noted here, so Washington recently, I think it was this year, imposed economic nexus on wholesalers. And it's questionably constitutional. So you're going to assess a tax on wholesalers without physical presence. So saying that a business that does nothing more than ship goods into the state is engaged in business activities in the state is a stretch. So at the outset, lawmakers suggested that they kind of knew it was a stretch, and they wanted to provoke a legal battle to re-examine Quill. Quill was a case from 1992 which established that a business had to have some level of physical presence in the state before the state could require it to collect and remit sales tax. It has, probably since, 1996, it's been slowly eroded at. And the concept is the internet. So now we have the internet, and you go on the internet and you buy your stuff, and there's really no physical presence, but that transaction isn't being taxed. And so if the business doesn't have physical presence, then there's a whole bunch of sales out there that are going untaxed. I suspect that Quill will be re-examined in the near future, and it will come to a different result. So now let's get into the fun stuff, the stuff I really like to talk about. Tax administration and transparency. So why I think transparency matters, and really the mission of Tax Analysts as a company, is that the debate is what is going to produce the best tax policy. As a company, we don't ever take a stance on what the best tax policy is, but we have the understanding that if we can provoke a debate about tax policy, we're going to get to the right answer. But to have a productive debate, you have to have information. a transparent system, there's always a desire for certainty. And we were talking about it at dinner last night. I was saying that when I ride my bicycle to work, I know exactly how long my commute is going to be. It is going to be 37 minutes unless I'm really tired and I pedal really slowly. But if I drive, my commute could range anywhere from 25 minutes to an hour. So there's always, I think the human mind likes certainty. We like knowing exactly what we're going to get into before we get there. And I truly believe that a transparent tax system leads to that. It leads taxpayers to know what the law is, they know how to follow it, they understand how it's going to be enforced, that it will be enforced, that it will be enforced consistently every time. So the need for transparency, I think that the federal government has all sorts of transparency issues, but we'll put those aside for the moment. State officials, though, may have more of a need for transparency because states tend to be less code-driven in how their tax systems function, and there's a lot more discretion that is allowed. And so I truly do believe if state officials are going to use discretion, they have to provide guidance on how that discretion is going to be applied. We have found the biggest transparency issues arise when states provide insufficient guidance on how they administer their tax laws and they have broad discretionary authority. So the benefits of transparency, for taxpayers, I put this slide in all the time, and it's really to focus on the state aspect of it. For taxpayers, the benefit is certainty. We know what to expect. It improves taxpayers' compliance. We are a voluntary tax system, technically. I suppose there's all sorts of penalties and whatnot, but still we are a voluntary system, and transparency improves voluntary compliance. For the states, I think it's a little bit more abstract. And I will admit I don't have any hard evidence to prove, but it seems that a transparent tax system would improve their efficiency. If taxpayers know and understand how the law is going to be administered, they are more likely to properly comply in the first time, less likely to have to call and have a whole bunch of questions. The state is less likely to have to issue tons of guidance of, what am I thinking of, regs and things like that will explain the law that has been put out. And controversies are less likely to go into litigation. If we have a question, it can be quickly answered. There's plenty of guidance out there. So Delhaize, and I think Delhaize really was what, it was a case out of North Carolina, and for my little world in Tax Analysts, it was the case where we thought like, oh, hey, there's some big issues out there that we should really focus on. So I'll give you a little bit of background into Delhaize, and in part because the discovery led to these emails that came out, and these emails were just horrific, but they're quite fun. So in North Carolina, they had a rule so they could force companies to file a combined return. So companies could either file on a separate basis, or if they were affiliated, they could file a combined return. So North Carolina had discretionary authority on when to require combination. The North Carolina Department of Revenue was alleged to have applied unpublished guidance to force the combination of affiliated corporations. Discovery in the case revealed the department's desire, the actual desire for a non-transparent system. So there was one email, and a Department of Revenue official contended that issuing combination guidance would, quote, be like handing a gun to a guy who is about to rob you. But then as the discovery went on, they realized that the guidance was not only being withheld from taxpayers, it was being withheld from auditors. So they specifically said the auditors, they weren't going to provide any guidance to the auditors because then the auditors might be able to provide guidance to the taxpayers. And so it really turned into be an internal problem. There was another, and the department said that providing guidance to the auditor, they wouldn't provide guidance to the auditors for fear that the guidelines would, quote, eventually fall into the hands of the dreaded Jean Horde, which apparently was from the film The Beastmaster, also known as taxpayers and their representatives, and will be used against us. So really, it was an internal problem, and I suspect that there are other states in which this is still the case, though hopefully and magically through through doing things like this and through doing more talking and things, that their eyes have somewhat been opened to the fact that, that taxpayers in the end will not stand for that. Eventually, North Carolina took steps to remedy its situation and limited the Revenue Secretary's authority to require a combination. But still, I think this case really demonstrates the us versus them culture that seems like it exists. I talked to a ton of practitioners in doing transparency studies, and that sense is there. I was talking to a practitioner this week, and it's the wonder of what's out there. What am I missing? If there's not sufficient guidance, there must be something else. And I think it's very difficult. So we went through and decided, well, okay, so if we decide that no transparency is bad, well, then what does good transparency look like? And so I say we, it's a couple of folks at Tax Analysts, and we sat down and said, well, here's what we're going to say is a transparent tax system. And then we evaluated all 50 states based on our criteria. So we looked at the publication of guidance. So do they publish private letter rulings or some sort of internal guidance? Do they publish administrative level tax rulings? And do they publish court documents? Are there clear audit procedures? And actually a big one, which is slightly tangential to transparency, is there an open process for awarding tax credits and incentives and an open process for following up on whether or not those credits and incentives have actually done something? So in the lack of guidance, we found that of the 50 states, 45 of them would issue a private letter ruling, and 35 then released those private letter rulings redacted. They would release them to the public. 10 did not. And we also found several states do not release opinions from administrative level bodies. So my three examples here, Kentucky does not release its administrative level rulings. And Tax Analysts actually joined a suit to compel the state to release redacted copies of their final rulings. And we won at the trial court level, and I actually should have quoted, and I don't have it in front of me now, I should have quoted the judge there. He wrote a very, very logical, well thought out opinion on why it mattered, on why these final rulings should be released and the guidance that they provided. And he very succinctly summarized the stress that there is between taxpayer confidentiality on the one hand, which should be protected, and the need for guidance on the other. Unfortunately, Kentucky has now appealed our opinion, and so we are going back to court in Kentucky to fight some more, so we'll see where that goes. Mississippi does not publish private letter rulings, but interestingly in Mississippi, even though it doesn't publish letter rulings, it still allows its attorneys to rely on those rulings in hearings, which I find very disturbing, because if you're not going to give it to taxpayers, then you yourself can't use it. It's like having a little secret library that you don't let anybody else in. And Washington State does not publish letter rulings or most appeals division opinions. So on the letter rulings, I'm going to take a stance and say the state should publish letter rulings because it would be very good. I will acknowledge that the confidentiality statute in the state of Washington will probably not allow that. It would require a statute change. The confidentiality statute in Washington is very strong. That is a good and a bad thing. It is good in the sense that taxpayer information should be protected, particularly individual taxpayer information. But it also makes it very difficult to properly and adequately redact so as to meet the statute. So there's a tug there. The big thing that I've always gotten after Washington on in articles is that they don't publish all of their administrative, all of their appeals division opinions. So that's their administrative level body. And the thing that got me initially was that there's criteria for when they will publish an opinion. So if it is decided that the opinion is precedential, it will be published. But then when I went to look at what opinions were out there, it was hard for me to justify in my head that they were really looking at this, these criteria and going through. It was just sort of the, well, maybe this one is easy one to publish, or maybe we don't care so much about this one, or maybe it's a, you know, it just felt that way. When you look at it and you say, well, if the department is issuing 400, but there's only, you know, 1% of that get out there, then I fall into the practitioner mindset of, then what am I missing? There's something out there that they don't want me to see, and that's then what I want to see. I want to know. I want to know all the tough issues. I don't want to see 3 sales tax letter or opinions out there. I want to see some B&O tax. I want to see some complex things. And so I wrote an article a couple of years ago, and I actually think since I wrote the article, I think there's been more opinions published, so I'm going to take that as a success. I talked to some practitioners about it, and they would love to see more. I had one say, well, you know, it was like going from 1% to 10%, so it's good, but we still feel like there's something else out there, and we struggle to get guidance. Now, let's take it back to the B&O tax for a second, and I think that taxpayer confidentiality really comes into play, and because of the B&O tax, and all of the classifications and just the way it functions, I will concede that it will be difficult for the department to adequately redact some opinions to the point that you would not be able to identify the taxpayer. The question then is, if it's a big corporate taxpayer, does it matter? Does it matter if their identifying information is redacted, but if you go through the facts, you could figure it out? Does that matter? Should that taxpayer better hide themselves? And I have to say, my hunch is no, it shouldn't. I think there should be a system for redaction. Many other states have a system for redaction, and it works. Sure.
Can you just explain to this group what redaction means?
Oh, sure. Okay. So redaction used to be you would take something and you would do a black pen and you would cross out what was there. So you're basically going to take it and you're going to eliminate so no one can see the taxpayer's name, their ID, typically their address, and any taxable amounts. There's going to be a variety depending on the state as to what information needs to be redacted. But it will be blocked out, and now they have great redaction tools, so it's blocked out, and you can't use some old docs that were scratched over. It's really easy to turn up the resolution on your monitor and see exactly what was underneath there, and now the redaction tools prevent you from doing that. So, but redaction is hugely important in the tax world because we do want to protect taxpayer confidentiality, and when having a discussion of transparency, it is never one of, we think that all of your tax returns should be online. Taxpayer information should be confidential. It should be treated with care. It really is more a discussion of getting the guidance out there, of understanding how the system works, of knowing what the inner workings of the department are. What are they thinking? And it really helps corporate taxpayers in particular, if they're going to enter into a transaction and they know what the department is going to do on it, they will alter their behavior. So independent tax courts are great. I think half the states now have an independent tax court. So I've talked now about the appeals division, which is housed within the Department of Revenue. An independent tax court or an independent tax tribunal would be housed outside of the Department of Revenue. It would either be in the judicial branch or I think we've seen some executive branch. But it is independent. You're going to have ALJs, the administrative law judges, that write the opinions for an independent tax tribunal. They will have specialized tax knowledge. They are not paid by the Department of Revenue. They're not in the hierarchy. And because they tend to be judicial, the opinions are public. It's if you're going to go to an independent tax court, the opinion will be published, just like any other tax opinion is. It will not be redacted at that point. So we are routinely pushing for tax courts, at least I am. And the Washington legislature, just this last session, I think, considered a tax court similar to the one that is in Oregon. The Oregon tax court does a very, very good job. Judge Breithaupt is fantastic. I've always appreciated reading his opinions. So there was a bill that was proposed in 2015, had broad partisan support. It did not move. So I have hope that it will be reintroduced in a subsequent year. It seemed as though it had, I talked to a variety of different groups to see, did somebody not like it? It seemed to have, from what I talked to a bunch of different types of taxpayers and practitioners, and everyone seemed to support it. So fingers crossed, because that would be a fantastic addition to the tax system here. So stepping away from Washington for just a moment, unclear audit procedures. This was one that we actually didn't realize up front. And I kind of fell into it and then realized it was more of an issue than it seemed. I started trying to gather up audit manuals. The IRS publishes audit manuals. It's what the auditors use to train, to go out, and they can look at it, they can refer to it. It should have all of the procedures for doing an audit. And I realized, and I said, well, I should have those for the states, and we should put that in a nice little database, and, and we'll sell it, and it'll be great. And then I realized, well, half the states don't make them available. So we did state-level Freedom of Information Act requests, and we got about 25 no's and a few yeses. And so I happened to be going through California's, and I came across a form. And I thought, well, this would be a really interesting form. It was on when California would require a combination. I thought, well, that's kind of interesting. I'm going to go ahead and try to see where that form is. And so I asked the Franchise Tax Board if I could have the form, and they said no. And I thought, well, that's odd. It's a form. It's like, I don't know how many of you filled out your tax returns. It's like a Form 1040. There's no taxpayer information on it. It's a worksheet. You fill in the blanks, and you do what it says, and you come to a result. And so we did a public records request for the form, and they said no again. And then we filed suit, and we eventually got it. And it seemed like the silliest thing, because when we finally got the form, and it really was just a form. It was a worksheet of you input A, you multiply that by B, and you get. It didn't have any great instructions to it. And as a side note, I realized I was at a conference and was talking to somebody from the FTB, and they said, well, now do you just want the paper form, or do you want the macro? I was like, oh, I didn't know there was a macro. Well, now I want the macro. I want to know exactly how it works, but I didn't get the macro. I'll get that next time. But that's a note. You should never say more than you really do. So unclear audit procedures. Taxpayers want to know how an audit is going to proceed, and I think they should. They should be able to see how the auditor is going to get from point A to point B. And I've had several states say that their audit manual contains confidential taxpayer information. Well, that's just a ridiculous assertion. It should not. If there's confidential taxpayer information in the state's audit manual, then they have bigger problems than just publishing it. These should be available. The IRS does it. Guidance should be out there for taxpayers. So incentives are there. States are going to use them. But what we want them to do is we want them to use them responsibly, and we want to know that when they give a taxpayer billions of dollars, that state is actually getting something from it. So I'm sure everyone here, you probably are aware of the Washington and Boeing. So currently, Washington state unions and lawmakers are up in arms over a decision by Boeing to open a completion and delivery center in China. And this is less than 2 years after Boeing received $9 billion in tax incentives to grow Washington state's aerospace industry. And since 2013, when the state awarded, it wasn't quite $9 billion, it was like 8 point something, in tax incentives, Boeing has announced layoffs, so that we're having repeated layoffs. And now Boeing has said, well, no, we established 30,000 jobs in the state, so we've upheld our end of the bargain. But it's really hard to find detail about it, and to really hold these corporations to task on, you've gotten this money. Now, what is the state getting from it? And so then we have Nevada and Tesla. This was a case of this package, the incentive package to Tesla, was so hustled through the legislature. And we always worry when things get hustled through the legislature, because it usually doesn't produce a good result. We've had this case in, we've seen it with tax policy. There was a pretty famous one in New York of the 3 men in a room. And so it was the governor and 2 legislators, and they would sit in a room and they would discuss the budget and they would figure it all out, and then they would take it to the legislature and they would pass it, and it all would happen in like 3 days. And that's not good tax policy. I mean, we need to have a debate. We need to talk to affected taxpayers. Let's have an open discussion about it. And so that was with Nevada and Tesla. I had the whole timeline, but it was hustled through. It was a big package. And then it becomes just incredibly hard to find any reliable information on it. And Sony, I had a reporter he's a fantastic reporter, and he spent countless days, I think, going through the Sony emails after they were hacked, and I'm not sure he wanted this task. But he went through and searched for tax in all the Sony emails, and you could really see how the tax incentives actually drove the behavior. And there were quite a few emails that would show they were very, very closely monitoring film credits. And now there have been a lot of studies out there that film credits, it's just a loser for the states. The only people that think the film credits really do anything positive for the states is the film associations. That really, and then you can even look at how they have done their analysis, and it's very easy to poke holes at it. So I think this shows the businesses are going to be very, very interested. They're going to follow the incentives that the state has. They will argue in favor of everyone they can get. States, in a lot of ways, don't have a choice in providing some sort of an incentive, but we want to see that those businesses then are being held to task. Oh, yeah, I forgot about Colorado. So this in my world is the Pinnacle. I got really fired up about this one when I realized it. I got we get a lot of documents at Tax Analysts, and we put a lot of primary source materials online. And one of my folks got an unpublished opinion from the Court of Appeals in Colorado, and it came with a big warning on it that we were not allowed to republish it in an electronic form. Like, but it's a public document. You can't tell me that we can't republish it. That is absurd. And so we called the court. No, that's the rule. So here we have, it's an Article III court, and 75% of their opinions are unpublished, and they are not releasing them. And the only record that we have of them is a list of the caption. So we could go through, and I request everyone that says Department of Revenue, but I have no idea if there are others. And when you really talk about secret law, that's horrific. I mean, there are varying levels when you get into court and you get into the legal world. Unpublished opinions are not always allowed to be cited. They're not always precedential, but they give a very clear picture of how that court is going to rule. So the idea that that an unpublished opinion would just simply not be available, I find is just absurd. And I'm going to I have to hustle now. I knew I was going to ramble too much. So roadblocks to transparency. There are a lot of roadblocks. One is information overload. So we're always in favor of guidance, but is there a point that guidance is too much? Like, you get too much information on something, is it simply too much information? The other big one, I think, is that states don't see the payoff. That transparency is going to require a change in their behavior. It's potentially going to require additional resources, and it is very difficult to make the correlation between that and that they will have a better tax system. And does that better tax system mean that it's going to come at a lower price? And then I've talked about this quite a bit. Taxpayer confidentiality is absolutely the most cited reason for not making guidance publicly available. My response to that is that redact. We can redact. There are redaction tools. There are 35 states out there that have successfully figured out how to redact private letter rulings and are regularly releasing them. The question then, is it too hard? Is it too costly? I would have to argue no. So for tax analysts, what's next for us? We are constantly looking, exploring a variety of states. I think we've written articles on maybe 15 states at this point and pointing out transparency concerns. We will continue to do that. We're thinking about trying to take this abroad and look internationally. That's a much more difficult process because just the legal systems abroad are unfamiliar to us, and so it's going to take more learning. We will try to obtain all of the audit manuals, and we will continue to dig into incentive deals. Oops, and I totally cut that off. And so I will turn it over to Gil, now that you have a blank screen.
That was our first speaker. Next up is Mr. Gil Brewer. Gil currently serves as Senior Assistant Director for Tax Policy for the Washington State Department of Revenue. He oversees the research and fiscal analysis, interpretations and technical advice, legislation and policy, property tax, and appeals division. And notice that last one, appeals division, because Cara spoke specifically about the appeals division. And has overall responsibility for the development of agency tax policy. So we have a pretty dead on in terms of the person that should be responding to this, and that's Gil. He earned a bachelor's of arts degree in English writing from the University of Pittsburgh, and his Juris Doctor from the University of Maine School of Law. I had my office not 2 blocks away from there until about a year ago. Mr. Brewer has been with the Department of Revenue for over 14 years and has held various positions, most recently as Assistant Director of the Interpretations and Technical Advice Division. He has worked more than 15 years of prior policy-related work in Micronesia, Maine, and Hawaii. Please welcome Mr. Gil Brewer.
I'd like to start by thanking Dr. Gramlich for the invitation and for Cara Griffith for agreeing to share her time and give us an opportunity to speak with you. I have to say, I don't know if I am pleased or scared by how many people are here for a tax discussion. Is there extra credit if you show up? Yeah? Okay. I feel better now. So I want to talk, and I will get to the transparency issues. I want to make sure I cover that. But on the B&O tax, a couple comments. I am not going to say anything about an income tax. One of the things you learn if you go to work for the Department of Revenue, everybody hears the story. 20 or 30 years ago, a director, newly appointed, goes to the legislature and they're asking this individual, what do we need? Why isn't our tax system working? And he says, well, we're one of the only states without an income tax. Maybe we should look at that. The next day, he was no longer director. So we do not use those words at the department. Second, Cara mentioned the complexity of the current B&O system. When it was originally enacted back in the 30s, there were, I think, three or four classifications, and there were very few deductions or credits. They have just mushroomed. And in fact, if you look at the growth, it's mostly been in the last 10 or 15 years. That's where most of them have been created. And the result is, yeah, it's complex. And one thing I've learned is sort of like the field of dreams. If you create a special tax preference, they will come. And they will try to squeeze into that. So the more you have, the more arguments you have about where people fit. So getting to the transparency issue specifically, I want to first of all focus on when you make comparisons with other states, and I don't envy you, Cara, in your job. I've done that in the past, and it is very difficult because states do things differently, they're structured differently, they use different terminology. So you have to be very careful when you make those comparisons. For example, when we talk about our appeals division, which is an internal unit within the department, you hear the word appeals and you think, yeah, this is an administrative appeal, but it's not done under the technical legal process, which is the Administrative Procedure Act, like it is in many other states. That is done in the state of Washington. That's done at the Board of Tax Appeals, which is a separate agency from us. All of their decisions are all published. The internal appeals are not necessarily all published. So when you look at another state and say, well, gee, all their stuff is published, well, if you want to compare apples to apples, make sure you're looking at an APA process and compare that to the BTA. It's different when you look internally. Same thing goes as well for the letter rulings. I know there are states that publish, and we heard states, we publish every one. We're like, wow, really? How do you do that? They say, well, we have 20, 25. Oh, we have 10,000. Now, obviously, people are thinking letter rulings are different things. If you just say a letter ruling, that's something in writing that comes from our taxpayer service division, and it answers a question. It may be a question, does Washington have an income tax? Nope, and that goes out. Doing 10,000 letter rulings, and of course you get the opposite extreme, very complex industrial, commercial transactions, and it can run the gamut. So again, you have to be careful what you're comparing state to state. So the redaction issue, which, and Washington State has raised that as a problem, and it can be difficult. It's not insurmountable. But for example, if you have a tax decision that says this case involves a large manufacturer of commercial airplanes, and they want to take a preference for commercial airplane manufacturing, well, you can't redact that to the point where you don't know who it is, or what you get is, we have a case, you win or lose, and you don't see anything else. That doesn't help. But that is not the norm. Those are really unusual. One other example, though, I'll give, you can go through and you take out the names and you take out the addresses and you think you've got it pretty clean. We had a decision that was proposed for publication, and part of the analysis the ALJ used in that case was to cite to a statement made on the taxpayer's website. And I thought, what if I just pull that quote out, pop it into Google? Well, sure enough, who do you think is the first hit? Obviously, the ALJ who was doing the redaction didn't think of someone doing that. But it can happen. And believe me, taxpayers are not happy when their competitor says, hey, I saw you got this great deal. I'm going to get the same thing. So it's an interesting balance we are put in the position of trying to strike at the department. And forgive me, I have some handwritten notes and I'm struggling to read my own writing. The bigger problem I think that we have when it comes to publishing determinations is that in Washington, if we publish an appeals determination, it is binding. Taxpayers can rely on it. The department cannot change that unless they want to withdraw the determination or make changes to a rule. So if we're going to put something out, we want to make darn sure it's right. And that is the biggest struggle we have with trying to get guidance out. It's not as much the redaction as it is to make sure that what we're providing to taxpayers is truly something they can rely upon and we agree with. And it's not as simple as you think. You will get a taxpayer comes in, they're making sales and selling software. And it's okay, under these circumstances, this is how we think the tax applies. Well, the next case comes up and they say, well, I'm selling software, but I'm selling it over the web. Well, maybe that's a little different. And if you're not careful how you wrote that first determination, you can have language that may suggest a certain result, but nobody thought about it because those weren't the facts in that case. And then you have someone says, I'm selling software over the web, but I'm not downloading it onto someone's computer. They're just accessing it remotely from a server based in Texas. Are those facts different? And it may well be. So you have to try to anticipate how someone is going to use that ruling in different circumstances. And that is hard. When we do something like a rulemaking that is going to apply general guidance on a subject, it is very rare that we get through it in less than a year. And usually it's longer than that. And you get input from many, many different people who are interested in that subject. When you have an appeals decision, you have one taxpayer and the department. And you don't get that broad range of input that you can get in a rulemaking process. So from my point of view, the biggest burden on the department is simply trying to make sure that what is written is something that is useful and reliable. The other thing I'll mention, and I will give Cara credit, I think you deserve credit for it. We have increased the number of appeals determinations that we issue. We issue a little less than 1,000 determinations a year, but about 400 or 500 of those tend to be very routine small claims cases or license suspensions, and nobody's really interested in them. What they're really interested in are the 400 to 500 mainstream determinations, and we had gotten down to publishing a handful, maybe 5, 6 in a year. And it was not because anybody made a conscious decision, we need to stop putting guidance out. It was because it was hard and it was time consuming, and we decided to use resources elsewhere. It was just, we're trying to make a decision, limited resources, and we chose other avenues. What we found after the articles came out and we talked to practitioners in the state, they really, really wanted this. So we ramped it up, we put more resources on it, and we are now publishing over 100 determinations a year. So that's roughly 1/4, 1/5 of the total number of mainstream determinations. So we've made a big improvement, and frankly, it hasn't been easy. It's a lot of work to get those things in shape and get them out. So one other thing that became clear to us when we heard from practitioners saying, we want more of this, let us know. We said, okay, well, we'll try. We're going to have to change some things to be able to get it out for you, but we'll do that. Sometimes you have to be careful what you ask for. Practitioners said, yeah, we want to see everything. We want it. Let's go. Well, what that meant was a couple things for us. One, we're going to make real sure it's right. We don't want to publish something and be bound by something that's a mistake, ends up costing the state millions of dollars. So that means it's slower. That process of getting decisions and getting them out has slowed down. Well, some folks aren't happy about that. The other thing that we're trying not to do, but it's a temptation, what's the incentive that's created if someone says, you have to live by every word you say? Well, you're not going to say too many, and you're going to be very careful you're not making promises you can't keep. So what's the easiest thing for the department to say when a taxpayer asks, can I get this break? No. No, get out of here. You know, in a year we'll figure it out, and maybe we'll tell you yes then. But if we're going to be stuck with the answer we're giving you and we're going to publish it, there's a strong incentive to just say no until a court tells us yes. And we don't want to do that. You know, we have a strong goal to get the right answer. And as we mentioned, it's a complex system and it's difficult. So we work hard, try to get the right answer, but there's a tension. There are mixed goals we're trying to reach, and the idea is to find a balance that provides the level of transparency that people are confident in how the system's being administered, but not so transparent that you distort the actions that a regulatory body takes. If I had one magic wand that I could wave and just make a change, I'd say let us make mistakes. We could get answers out faster. We could publish things as long as the next time we get an issue and we say, oh, we understand it better now. We've talked to the software manufacturers who are on the web, and now we want to clarify this and fix it. Well, we can always fix things in a taxpayer's behavior. And so, yeah, say no, then we can fix it. But if we give a benefit to a taxpayer and try to take it back, there's hell to pay. Courts don't like it. They look at us and say, you're flip-flopping. I won't even get into what legislators tell us. It's very hard to make that change the opposite direction. One other thing we tried to do, as I mentioned, when we ramped up the number of publications, we made an effort to make sure we were being consistent. We had a greater effort for our policy staff to get involved earlier with the operating division, so with an auditor or someone in our tax account administration division, get their advice in, make sure that we broadcast that advice through the agency so that everyone knew what we were doing, and then try to take that process when we got answers and put it into public guidance. So the first thing we heard was, you now have secret policies. You guys are doing all this stuff and we don't know it. We're saying, well, we're going to get it out. It takes time. Then we heard we were fixing the results of appeals, so taxpayers always lost because we were having communications internally. The last thing we heard was, okay, well, I'm going to start asking for confidential taxpayer information in discovery because I don't think you guys are doing the same thing throughout the agency. And that really got some taxpayers' eyes opened. They're saying, wait a second, my stuff's going to go out? We just recently had a meeting with the credit card processors. It's involving how we tax interchange fees. If you guys want to blow your minds, that's a fascinating subject. So part of that, we said, well, one of the things we really need to determine if you're taxable or not, we need to see the contracts you have with the merchants that you're doing the credit card processing for. And they were, you know, this is very sensitive. It's a low margin, high volume business. These could really be competitively sensitive. And I had to tell them, you know, by the way, practitioners are asking us to disclose this stuff. We'll redact your name. They won't know it's you, but they will see the substance of your contract. These taxpayers were not happy. They didn't want that to happen. So I guess just to kind of sum this up, I don't think there's a dispute on the benefit of transparency. If anything, at least in Washington State, that second part of your slide where it said, you know, do states understand the benefits? We absolutely do. I mean, I would love to have guidance out on every issue possible and have voluntary compliance because most taxpayers do want to pay what they think is due. But it's complex, and there are competing goals in the system, and it's going to require trying to balance those, and that's going to require talking with practitioners, with taxpayers, with members of the trade press, with the regulators at the department, with the politicians to understand there are a lot of conflicting goals. We want to try to do this the best way possible. And I think the first step in that is, for some folks, don't be paranoid. This issue, the tax system is complex, it's hard. That's why so many people make their living off it, because it's a tough topic. Don't assume that the State Department of Revenue, or any other that I'm aware of, is just out to screw taxpayers. That's not our goal. Our goal is to administer a complex system as fairly as we can, as consistently as we can, and it's a tough job. So don't be paranoid. ratchet down the rhetoric. There are no secret policies. We're not hiding the ball. We're trying to get information out the best way we can. And to do that, we're going to need input from everybody. And we're going to need cooperation. And hopefully that will continue. As I said, we've made some strides in this area. We've drastically increased our own publication of appeals determinations. And we plan to continue to find ways, innovative, new ways, to get information out to taxpayers. So again, I just want to thank folks for giving me some time to chat. Happy to do any back and forth that Cara and I may have and open it up for questions. Although back and forth, I guess we're going to like, yeah, pass this. You want to come up?
So before we open it up for questions, and I do apologize, we apparently have a dead battery as far as the lapel mic, but I thought we would give a chance for both of the speakers to go back and forth with a few questions that maybe they each have for, as far as expectations coming from Gil toward Cara, and maybe Cara might have some questions about what has been done so far or something along those lines. But they do have one mic at the moment. We are trying to get another one, but apparently somebody had to run to 7-Eleven.
So does anybody have any burning questions? Well, I actually have one that I'll pose to you. This was one that I was talking to a practitioner, and you mentioned how difficult it is, and you guys don't want to put something out if it's not right and you can't rely on it. Well, so it's going to have part of a question to it. One, are appeals division opinions binding on only the taxpayer to whom they're binding across the board? Okay. So then the question that was raised to me by a practitioner, and it was in response to a case, and I'm going to admit that I have not read the case. It was Avnet, if you're familiar. And so his concern was they don't feel like there's anything they can rely on. And they were concerned that, and in that case, it came down to, and you probably are better positioned to speak about it, that there were some interpretive rules and the taxpayer was not permitted to rely on the interpretive rules. And so the practitioner mentioned to me and said, well, we're worried that we're running out of things that we can rely on to provide opinions to our clients.
Not very familiar with the Avnet case, and I have had this discussion. I think I know which practitioner, and I've had the discussion with them. It's one thing to get guidance out. That's great. It's out there. Everyone can see it and read it. If you have ever written something like that, you know as soon as you get it out and a dozen lawyers see it, you get a dozen interpretations saying, I didn't mean that. And that's what happened in this case. There was guidance put out. If I remember in Avnet, the issue was a drop shipment question. And we had an example in the rule, and we said, this is how it would be taxed. And you read it, and it implied a similar result in different facts. And clearly, I understand the argument this practitioner is making, that the language was there. You could read it that way. Our position wasn't that you can't rely on the rule, but that we read that language differently. We think it means something else. And the reality is, it is darn hard to write stuff that is perfectly clear that everyone who reads it has the same understanding. So in this case, this is one where, again, I want to go back to that, ratchet down the paranoia. We're not just telling you we're going to ignore our own rules. This is just a case where there's an honest disagreement between parties as to what that language means. And that's going to happen no matter how well they're drafted.
Of course, I'll have to tell you, it's the job of the press to be paranoid. It's what we do. Yes?
And I will also add, I'm sorry, but I will also add, we recognize we're the tax guys. Nobody likes us. We're not winning popularity contests, and that's simply a matter of life for us.
Please stand, and I'll be standing back
fast forward then to the Great Recession, when the tax system was clearly not generating enough revenue for the state, and you had caseloads going up, revenues going down, and the legislature didn't want to radically change the tax system in the state, but they needed revenue. And so where did they go for revenue? They reduced the funding for higher education, in the case of this institution, by about 50%, a huge amount, and then they incentivized the state universities to raise tuition. So I would argue the biggest tax story of the last 3 biennia has been the increase in tuition that students have been asked to pay because the legislature couldn't come up with other sources for tax revenue. Now, they reversed that a little bit last year and are now reducing tuition. But I would argue if we ignore what students pay in tuition, that ignores a big source of tax revenue and a big issue for the state.
Boy, you're playing to the audience. I'm actually leaving employment with the state at the end of this month, so I'll say some things I probably wouldn't say otherwise. Drew, don't shoot me. Drew Shirk is going to be taking my job. If you go back 20 or 30 years and take the tax system we had in place then, and if that was in place today, there would be no budget crisis. We would fund McCleary plus. So the budget crisis, in my view, is self-created. We have, as a state, we've made the decision to reduce taxes in certain areas, and as a result, yeah, you don't have the money for things that some people want to spend it on. Now, of course, others will say we shouldn't be spending it to begin with, but that's why we have votes in elections. But there's no question that the legislative actions have reduced the amount of revenue coming into the state, and in essence, required other forms of taxes, whether it's fees, whether it's requiring local governments to provide services that the state isn't funding, witness Cleary, or increasing tuition, which is simply another kind of tax.
Yes.
So I want to go back to your reason.
And I'll go back to that one.
So I want to go back to your argument about transparency, because what you both agree about is that there's real benefits to transparency, but there's also real costs associated with it. So my question is, and it's probably to you, Cara, have you thought through the cost-benefit analysis? How do we know when the benefits of transparency are outweighed by the cost of producing it? And what's the formula we use for that?
That is a really good question, and I'm going to be honest that I have not yet figured it out. I don't think that we haven't had a solid test case where you could take from point A to point B and look at it. So I don't know, and I suppose there's going to be some level of requiring to see how many bodies are going to be required to do the redaction, how many bodies would be required to produce the opinions, how, it's going to vary by state, and I will be honest that we have not figured it out.
I'll just add, I think it's a case of you know it when you see it. I mean, clearly the 4 or 5 appeals determinations we had been putting out weren't right. That was wrong. And we've taken steps to fix that. Now, is 100 right, or is 150 substantially better? That's a tougher call. But the extremes you can see. Oh, I'd love to. This is an issue we've been having some very heated discussions with the tax practitioner community. Part of the problem is the way our system was set up. At one point, the legislature passed a law that said you have to provide a form of internal review in the department, and the department has to take another look and make a decision if a taxpayer questions it. That was, in some ways, unfortunately handed to a lawyer. And, well, what's a lawyer going to do? A lawyer's going to set up a process that the lawyer's familiar with. So we're going to have briefs, and we're going to call it an appeal, and you're going to have a hearing, and we're going to have a docket that we keep these things on. Well, that sure sounds like a trial, a court process. So over time, it was not unnatural that taxpayers looked at it and said, yeah, well, I'm going in front of an administrative law judge. I'm having my hearing. And then they find out, well, wait a second, you work for the department? You know, they pay you and you're deciding my check, or you're deciding my case. We had some problems with that. People had perceptions that weren't the reality, because the reality is it's the department's decision. It's our internal review. You get that independent review when you go to the BTA. So we would have internal discussions. We'd have policy groups meet and assist an ALJ in making that decision. We want the decision to reflect what the department's view is. And some practitioners are very unhappy with that process. They want that independent person who's going to be a check on the department. Our position is, well, you get that at the BTA. We want to get the best decision from the department we can in our internal process. But if you want to make it more independent, if the legislature chose to do that, that would be fine. But when you do that, then that probably means we're going to have to bring the Attorney General in to represent us. That means you're probably going to be creating a record for the appeal beyond there. That means that informality in the current process, where it's really taxpayer comes in or their rep and they sit down with an ALJ and they just talk about the case. Well, that's out the window. If you want it to be more independent, then it's got to be more formal. We have to have a right to appeal. If we don't like the ALJ's decision, we need to be able to take it to court. Currently, we do not have that right. So again, it's a matter of education and balancing, and there's no right answer, but there is a very healthy debate going on right now about exactly where that line should be drawn.
Yeah, I mean, I can say from many interviews with practitioners that the perception is that the appeals division functions like a court, and therefore it is perceived to be a court. And I would note, and this is maybe more of a question for you, if a taxpayer goes to the BTA, do they have to pay, is it a pay-to-play?
It is not pay-to-play for the BTA. It is pay-to-play means you have to pay the tax in dispute before the forum will hear your case. That is required if you go to a judicial appeal. It is not required at the BTA, but going to the BTA does not stay our collection efforts. So we're going to come after you for the money while that case is being heard. And that's an issue where, from the department's point of view, we have no position on that. And there have been various efforts, and the bill that Cara referred to earlier in the tax court would have repealed pay-to-play. And that makes no difference to us as a tax collector. What it does do is there is a one-time hit to revenue, because at some point, people are not going to have to pay. Well, that's money the state normally gets. So when you make that transition, there's going to be a hit to their revenue, and they're going to have to pay for it. They're going to have to fund that or make cuts somewhere in the budget. But that's not a department administrative issue. That's a legislative budget issue.
Oh, that's right.
I have a question for you, primarily for Gil. My question is, at one point in your presentation, you said that when one taxpayer gets a special tax break and another taxpayer would find out about it, the first taxpayer would be upset. Is that correct?
I think that's how I phrased it. I didn't quite mean it exactly like that.
So I was thinking about Seattle's Best and Starbucks, and why wouldn't we want Starbucks to learn that Seattle's Best got a tax break, and wouldn't we want them to get the same tax break under the same tax circumstances?
Well, let me clarify first of all. If the facts of the two taxpayers are exactly the same, we darn well better be treating them the same way. I think.
How would we know?
So, trust me. No. The problem that the taxpayer would have, twofold. One is just the regular competitive issues that I mentioned, the interchange fee issues raised. That's not is someone getting a better tax treatment. It's just my information is competitively sensitive and I don't want it out there. On the issue of whether someone is treated differently or not, you may have a taxpayer who creates a corporate structure that ends up giving them a certain benefit. And they don't want someone else, and they probably paid a firm a fair amount of money to come up with this, and a firm is out there trying to market it to other people, and they want to make money off it. Our job as tax administrators is not to give advice to people on how to minimize your taxes. You can structure your business, you can create affiliates any way you want for any reason, many of them having nothing to do with taxes. But if somebody comes up with a creative way to do that, I don't see that it's the department's job to go out and tell everybody, you can all cut your taxes if you rearrange yourself this way. Now, getting to the question of should it be published or not, that's an interesting question. I think the taxpayer who has that benefit, the firm that created it and is trying to market it and make money off it, isn't going to be happy if we put that out. And on the other hand, our job is identify those cases that seem to make sense on a broad scale for people, and that could be one that makes its way through the publication process. But it doesn't mean someone won't be unhappy with it when it does.
Yeah, I would say a case like that should make its way through and it would, of course, be my job then to push for making sure it does, because that would probably be an interesting opinion.
Sir, please stand.
Okay, so my question...
I can't hear you.
Okay, good to know. Okay, so my question might be multiple part depending upon how Gil answers these questions. So who exactly or which body determines your budget?
Our budget's set by the legislature.
So then if a legislative body wants to go ahead and push through a tax incentive for a business, let's say Boeing, specifically for the state of Washington, what type of pushback can you do to help equalize it for the other firms that are also in aerospace?
We have a statutory obligation. It is written into the DOR statutes that establish us as an agency to provide advice and assistance to the legislature on tax legislation. And the way we have always interpreted, at least while I've been there, interpreted and applied that in practice is we do not generally take positions on whether it's a particular rate should be increased or decreased, or whether a particular deduction that's proposed is a good idea or not. We focus primarily on, can we administer it? Is this something that is going to be practically possible? And does it fit into the tax code well? Or maybe there's an alternative that will accomplish the same goal, but do it simpler and be easier for both the taxpayer and the agency. We tend not to take positions on the merits of should this taxpayer be taxed more heavily than another. And that's how we interpret the role we've been assigned by the legislature.
Okay, so then assuming that Boeing got a tax incentive, isn't there an incentive to make sure that, let's just say that other aerospace companies don't necessarily find out? Because if a politician is setting a budget and they do not like it when their big industries are not getting their tax incentives and they're not getting what they want, and business isn't increasing and they're not looking as good, isn't there an incentive then for you to kind of remain quiet? Because then you get yelled at by legislation because they want more business.
The aerospace incentives in particular, I'll point out, recently they have included more transparency measures in them, requiring reports back from Boeing. In fact, we've only recently had to deal with some members of the press wanting access to that information. It is always a delicate balance. You know, the reality is, if taxpayers didn't voluntarily pay 97% or more of their taxes, there is no way we could go after all of them. We don't have enough resources in the state, much less in the agency. So you're relying upon taxpayers' faith and trust in the system, that they are being treated equally with others, which is one of the reasons why transparency is important. On the other hand, too much transparency, and you get the people saying, oh, be darned if I'm going to give you this because I don't want people to know it. And then we have to go out and track them down and fight with folks to get it. It is a very delicate balance. And I agree. I mean, there are incentives in many directions that are created when you create tax incentives, beyond simply the fact that someone gets a benefit. It influences behavior, which is why classic tax policy theory is low rates, broad base, simple, and avoid all this distortive effects that special provisions create. The reality is that legislators respond to incentives other than good tax policy. That's one of the areas that I think the Washington Department of Revenue does a better job than many states. I mean, everybody does some things well. I think one of the things we do is we do have a very active program to reach out to taxpayers as much as we can and get information. We have worked very hard to put things in plain English, try to simplify, try to make them understandable, and reach taxpayers directly. You will never get everybody. There will always be some folks who miss the boat and don't quite catch on, but we make the best effort we can.
Yeah, I would concur with that. The Washington Department of Revenue has a lot of general guidance that is plain English. It's easy to comprehend. On the incentives, I think potentially using aerospace is a bad example. In terms of transparency, I think from my perspective, we often see some of the worst transparency when you get incentives that are offered by localities for property tax. And they are offered by a small board of people that work part-time. And those are really the deals, I think, that are much more difficult to uncover. The big ones, like with Boeing, there's a paper trail. You know you're going to get information.
It's hard to hide $9 billion.
But it's not that hard to hide when you're talking in the hundreds of thousands, and a board of people that have full-time day jobs, and they just meet once or twice a month, and they're negotiating these deals. So that's a much more difficult transparency issue.
Thank you.
Thanks.
So Gil, I know you mentioned before that each state does everything differently. Cara, have you seen any states that are producing these letter rulings really efficiently? And if so, what can Washington do to reach that level?
Well, I'm going to qualify this with that every state does it a little bit different. So, I mean, if you look at a state like Texas, you can get almost all of their rulings. They're very quickly released. Trying to think of another state. Gosh, I want to say one of the Midwestern states does a fantastic job. They're released very quickly. They're online. They're categorized. It's a very easy, quick, clickable thing. What can Washington learn? It's going to come back to, I suppose, for the department to sit down and say, can they do it? And what is the initial output? What is the initial cost to the department going to be? Can they adequately redact? Can they do that within the current statute? If it's going to require a statute change, then that's going to have to come before they would take any steps. There are quite a few states that have figured it out, but it's within their own system. So I will grant that every state is going to be slightly different.
If I could make one suggestion, it would be that if they want us to publish them, they not be binding. That makes it a lot easier.
That's a point. That most often, in most states, a private letter ruling is going to be binding only on that taxpayer. It is not binding on anybody else. It can be precedential. You can use it. You could cite to it. You could take it. You could take it with you and say, well, look, here's how so-and-so was treated. but it is only binding on the taxpayer to that particular situation. It is not, it carries less weight.
And that's,
Correct.
and as it should be, because letter rulings simply don't get the same level of analysis that an appeals determination would.
And you want them, you kind of don't want them to. You want them to be produced quickly. You want taxpayers to be able to request a ruling and get it within, you know, a 60-day sort of time period. You don't want it to take a year, because then their transaction that they were worried about has already occurred, and there's really no going back.
Yes. So it sounds like since Washington has kind of internalized so much of its revenue system with our letter rulings, as the representative of the Revenue Service, would you say those would become more accessible to all of the firms, all the taxpayers, in an effort to increase transparency, since those letter rulings carry so much weight?
Our focus has been on the appeals determinations, which is where most of the interest was expressed. If we get to that same level of interest in letter rulings, then we will have to address that. But as I said, I think it's going to require, at the minimum, some legislative changes to make it practical.
I think what I had meant by making the letter rulings accessible was, if I wanted to submit a letter ruling, the service is very efficient at getting results back to me as the taxpayer.
That depends on how hard your question is.
That's right.
I mean, I'm trying to remember. I think the deadline is 10 days for a response for letter rulings, and we do that for most, but there are always some that come in that, we just got one the other day from a very large taxpayer. You'd all know it. It was 20-some pages, just the question that was asked. That's not going to be done in 10 days. Now, they're not expecting an answer in 10 days in this case, but we do our best to try to get those answers out quickly, and we've made it as accessible as possible. You can do it online. You could submit it by email. There are a lot of different ways. We now have a live chat feature where you can just ask someone and get the answer rather than calling the phone center. So we're trying to get that information out, but again, how accessible and how long often depends upon what you're asking for.
Does Washington State have a taxpayer advocate?
We do, although the name taxpayer advocate may be about as helpful as appeals. The taxpayer advocate in Washington does not go and represent or make arguments on behalf of a taxpayer. They will follow up, they'll track down, you know, where is this case? Has it been lost? Is someone actually paying attention to it? And make sure that it's being handled properly, but it is not. Sometimes folks think, oh, this is someone who's going to help me make my case, and that is not the role in Washington.
Yes.
One last question, please. Yes, I was wondering if each of you could maybe briefly speak on the public interest behind the transparency. I know, Gil, you were talking a lot about, and both of you, in any taxpayer discussion, we talk about the taxpayers, but I think there is a public interest here, and I think we have to account for taxpayer transparency, but I wonder what the cost-benefit analysis is there of releasing that potential private information versus the public interest in having the information.
Tax Analysts as a company has always stood behind the public appeal, is that more information will produce a healthy debate, and a healthy debate will produce solid tax policy. We have never advocated for the release of confidential taxpayer information, and I don't think would, but so I think my answer is twofold. It is that it does produce a better discussion about tax policy, and it allows the public to ensure that similarly situated taxpayers are being treated as such, which I think goes straight to the heart of a voluntary tax system, and that if I'm confident that if my tax position is the same as your tax position, that you and I are being treated the same, and we are more likely to comply.
A very tough question, good question, and it's on both sides of the spectrum. You want to be sure, as Cara said, I'm being treated the same as everyone else. Well, part of that is also, well, what are these incentives that are given and how much are they benefiting so that I know what tax burden is this person paying compared to mine. We may be both following the law, but it's awfully hard to keep track and understand how all those incentives work and what it does to your overall tax burden. And that's something the legislature in many states, and in Washington in particular, they've been struggling with. What level of transparency will make that possible for an average citizen to see what's happening?